Good afternoon, everyone. Thank you for joining us today. I'm Lauren Smith with the International Franchise Association, and we have a great session lined up for you. Before we begin, I would like to let everyone know that we are recording today's webinar and will make it available later this evening on community.franchise.org. If you have any questions for today's speakers, please add them to the questions box and they will be addressed toward the end. Today's topic is what franchise companies should be doing in the metaverse and with non-fungible tokens. Here to provide today's discussion are Craig Tractenberg and Lori Kozak. Craig is co-chair of the firm's Franchise and Distribution Practice Group, focusing on domestic and international dispute resolution and the development of infrastructure, licensing, distribution, and franchise programs. Craig's retail experience includes the representation of restaurants, pharmacies, apparel, educational, and automotive retail chains and franchise systems. He also represents jewelry and watch brands, both domestic and internationally. Lori is co-chair of the Trademarks Practice Group and provides global strategic management of trademark portfolios for multinational corporations, technology startups, and entertainment companies. Prior to entering private practice, Lori was a trademark examining attorney for the USPTO, where she examined and ruled on trademark applications for registration and represented the USPTO in appeals before the Trademark Trial and Appeal Board. Thank you all for joining us today, and thank you to Fox Rothschild for sponsoring today's webinar. I will go ahead and turn things over to you.
Well, good afternoon, everyone. I'm Craig Tractenberg, and Lori and I are going to take you along with us in learning about the metaverse and also NFTs, non-functional tokens, and assets which are used in the metaverse. We'll tell you why it's important for you to know this, even though you have no intention of starting a virtual world, because one day you'll have to experience one. Let me see here. So I have a problem with the presentation. Hold on for just a moment. Someone else will have to put the presentation on their screen.
Lauren, can you assist with that?
Yes, absolutely. Just a moment.
Lauren, it may have had to do with what you were doing.
Oh. Okay. One moment.
Okay. Okay, let me try it this way. Can everybody hear and see me? No.
Go ahead, Craig.
Can everyone see my screen?
Yes.
Okay.
Can you advance it to the first substantive?
Yes.
There we go.
All right, so I can't see anyone. I can only see the screen. I'm advancing it now. Can everybody see the advance?
Now, Lauren's going to advance it, I think, Craig, and you'll just tell her when you need next slide. Tell her when you need next slide.
Okay, fine. So, next slide. What is the metaverse? What are we talking about here? In the most narrow sense, and for the purposes of today, the metaverse is used to describe a network of 3D virtual worlds where people can socialize, learn, interact, experience, and conduct business. It's really a social setting for them, but it's not the real world. It just has things from the real world posted in a virtual world. Sometimes we refer to this as Web 3.0. It's a virtual reality version of the internet that we know and love. And this presentation will discuss how to protect your assets once you understand the new risks. And these new risks, as we'll find, have nothing to do with whether you use the metaverse, it's whether other people use the metaverse. Let's go to the next slide. So imagine the future, which is now. We just may not have all experienced it. Let's go retail shopping. So we log on to mallverse.com, and there's a virtual mall, just like the big mall that we sometimes go to. or the teenagers hang out at. And so there's an avatar that you have pre-programmed. You are going to use this avatar to visit a place where you can get a high-end blazer, a jacket, or go to an eyeglass retailer. You enter the store, your avatar already has your dimensions for fitting and eyeglass prescription. And remember, these are all personal data items we'll have to talk about later. And for perhaps a nominal price, you'll buy an NFT, a non-functional token of an item, which you may have used your cryptocurrency wallet or Apple Pay to buy. And that allows you entry into the store and a discount. It's kind of like a credit card, at least this NFT is. And you order these things, you try them on. You can see on your computer screen how they fit you, whether the eyeglasses are right. And you push the button, you pay for it, and you'll get free delivery at your home by Amazon the next day. What I'm describing is not really the future. It's now. You can do this. But when you're shopping, you may get hungry. So you go to order a hamburger from the virtual McBurgers, and you have it delivered to your home while you're still on your computer. It's prepared in a ghost kitchen. That's a kitchen that's not branded McBurgers, but it's within the delivery distance of your neighborhood. And maybe the closest franchisee of McBurgers can get it delivered to you. And Uber Eats or some other delivery service can deliver it within 15 minutes of you ordering it, sometimes by an autonomous driver or by a drone. You pay for it with your crypto wallet or the NFT that you bought earlier from the clothing store, which co-markets with McBurgers. While you're at the mall, there's an educational franchise or a rock school franchise. You go in. Maybe your child wants to go in and dip their toe in the educational component, try out some of the quizzes, or want to do karaoke or learn math in this virtual world. You can do that, and you can do it today, and your competitors will be doing it. That's the way things are today. We're going to make friends with some of the digital assets in the metaverse, but first I want to tell you about what Wendy's is doing, because they're pretty much at the forefront of this. You, without the Oculus contraptions, can go onto the wendysverse.com. And once you go there, you can go onto the Wendyverse Town Square Central, with a Wendy's restaurant replicated in the virtual world. You can go there behind the counter with your friends who might join you and cook up Wendy's meals. You can go to the Wendyverse Partnership Plaza, where players can visit the Buck Biscuit Dome to shoot hoops with a virtual Baconator and cut net with the winning shot. And if you go during certain times, you can even get a bacon, egg, and cheese biscuit for $1 at a real life Wendy's. And the intent of this is that even though the full vision of the metaverse may be years away, brands are experimenting with what a metaverse presence will be like. So here's the digital assets that you'll see in the metaverse. These are just the beginning. You'll see a lot more. We know about cryptocurrencies and payment systems because a lot of us pay with Apple Pay or PayPal or Bitcoin. They'll have more. There's more cryptocurrencies, obviously, and in the metaverse, it's going to be easier and easier to use these payment systems. You'll use probably something called an NFT, a non-fungible token. An NFT is a financial security. It consists of a digital data item stored in a blockchain, which is just a form of ledger. And the ownership of an NFT is recorded in this blockchain, that ledger, like a bank book, and can be transferred by the owner of the NFT, allowing the NFTs, which are replicas of the actual creative art that's on the NFT, to be sold or traded. Often NFTs contain a work of art and its content is protected by copyright law if it's something that's creative. But remember, when you buy the NFT, you're not buying the actual art, just a replica of the art. A crypto wallet is a device, a physical medium, a program or service that allows storage and use of digital assets like NFTs and cryptocurrency. The crypto wallet contains information in it. And when things contain information, we have to think about privacy. When you had the pre-programmed avatar with your measurements, so you go shopping in the retail mall, that's a privacy issue. And whoever collects the data has to be responsible for the privacy issues. If you could flip to the next page, please. Using digital assets for branding companies. We're going to be able to use them for payment. There's NFTs usually are used for collectibles, but NFTs can also be used for payment. They can have a payment component, and they have coupons and discounts that are available. And with NFTs, the Metaverse promoter is going to allow access to tickets or discounts or sporting events. Maybe you'll see premium movies. And you can also co-brand. The food distributor in the virtual mall may team up with the haberdasher through the NFTs. So you buy the NFTs and you get all access. And that's the way they're going to distribute them. Now, Lori, if you could tell us, based on what you've heard so far, if we're not in the metaverse, do we have to worry about any risks to our trademarks and intellectual property?
Yeah, absolutely. So, let's say you're a franchise company and you sell sandwiches. You've got absolutely no interest of being in the metaverse at all. And that's great. But the problem with that is if you're not there, somebody else will be. So let's take the McBurger example, right? So traditional trademark or unfair competition or copyright infringement in the virtual environment can happen. And the McBurger example that Craig gave is a really good one. If you order a burger at a virtual restaurant and it's delivered to your home, an actual authentic, an actual product, if somebody is using, McDonald's or McBurger or some other well-known brand for that burger or that food delivery service, that's a pretty traditional trademark infringement, right? It's unauthorized use of a brand on actual products that are not. You mean
there'll be a virtual pirate in the metaverse who uses the brand but delivers a spurious hamburger?
That's right. Who knows where that burger came from or what's in it? So, and then you have the types of trademark or intellectual property infringement in an NFT. And so there's an interesting case that's really active right now is Hermes International versus Rothschild. It's a case that was in Southern District of New York, and I'll talk about it a little bit more in a moment. But it's one of the first cases where we're seeing the courts wade into this issue.
That's the artist Mason Rothschild, not the law firm Fox Rothschild, right?
Absolutely, no affiliation whatsoever.
Okay.
The other area I'm going to talk about briefly after the Hermes case is decentralized domain names. So there's a lot of different ways in the metaverse that you can have your intellectual property infringed upon. The Hermes case is really interesting because it's an NFT case, and NFTs get a little tricky, right? Is the usage, is it artwork? Is it something that's protected by free speech, First Amendment? Is it a commercial use? So it falls under more traditional trademark analysis. And in this case, Hermes owns the trademark Birkin for handbags. And Birkin is named for a French actress, Jane Birkin. It's a very exclusive handbag. It can sell anywhere from thousands of dollars to even over $100,000, according to the complaint. Mason Rothschild is an artist and a marketing strategist, and he created and started selling digital images of Birkin handbags covered in faux fur. and he's selling them as NFTs under the name Meta Birkins. So he was selling them not only through a website, digital storefront, social media channels, and Hermes sued. They said that these Meta Birkins NFTs infringed and diluted on the famous Birkin trademark. It also falsely designated the origin of the NFTs because consumers would be confused and believe that they were Hermes authorized digital products, and that it injured their business reputation and diluted the trademark. They also asserted a claim for cyber squatting because he was using metabirkins.com. So Rothschild argued that, look, this is free speech. It's protected under the Rogers versus Grimaldi case, right? That's a famous case where Ginger Rogers sued over the use of Fred and Ginger in the movie title, and the court basically said that you can use a famous trademark in connection with a work of art, and that is not infringing, so long as the name is minimally artistically relevant to the product, and the use does not explicitly mislead as to the content or the authorship, sponsorship, or endorsement. So the artist is saying that, look, it is, the name Meta Birkins is at least minimally artistically related because he's making a statement about the fashion industry's animal cruelty and the nature of luxury and value, and that the term is not explicitly misleading, despite the fact that some people were confused. And Hermes said, look, that's not all you're doing. You're not just you're making art. You are selling this. You are making extensive commercial use. You're selling other products under that name. You have digital storefronts under that name. You're using it for marketing campaigns. And that there is a lot of actual confusion in the marketplace that this might be something that Hermes was associated with. The artist himself was noted saying publicly that Meta Birkin was a digital commodity, and that there was not that much difference between having an iconic Birkin in real life and having one in the metaverse. Interestingly enough, people started selling counterfeit Meta Birkins, and he had a problem with that. So the argument here is that it's not just art, it's a digital commodity and should be protected against trademark infringement. There was the motion to dismiss based on the Rogers versus Grimaldi case was just ruled on last month on May 18th. And the judge denied the motion to dismiss, so the case is going to go forward. And the judge said, look, Rogers does apply, at least in part, because the Meta Birkin NFTs, these digital images of handbags, could constitute some form of artistic expression, regardless of the fact that the artist also used the label to market and advertise them. That said, the judge did not rule whether or not the label was minimally artistically relevant. He said that's going to go forward, and the artist has made a lot of statements to the press about his efforts to create some sort of illusion that the Birkin bag is in real life is just as iconic as in the digital community. And Hermes had adequately pleaded that the Meta Birkin label was explicitly misleading. And so that's sufficient to state a claim and allow the case go forward. So this is really one of the first rulings we've seen to see how courts are going to treat these types of cases. In this case, I think obviously the judge was influenced by the commercial nature of Mason Rothschild's use. And he's looking forward at what this looks like for future sales of virtual goods in a metaverse or an enhanced reality context. So, the court interestingly noted that the NFTs might not qualify as artwork if they were attached of a digital file of a virtually wearable item. So if you could walk around with your avatar with that handbag, that might be different. But because that was only really suggested as a possibility and wasn't taking place, he didn't address that issue specifically. So there's another case that I'm going to mention briefly. I don't have a slide on it, so we can just hold the slides where they are. If you can go back one, which is the Nike case versus StockX, and it's getting a lot of press right now as well. StockX is an online sneaker retailer. It launched in 2016. It sells other products, but mainly sneakers is its biggest. And its top 5 products, I think 3 of them are Nike brands. So StockX has a thing where you can buy a sneaker on their platform, and they have an authenticity guarantee that StockX claims ensures that the items that are traded on StockX conform to their product description, that they're authentic, they're not counterfeit, defective, or used. So if you buy a pair of shoes on StockX, the seller ships the shoes to one of StockX's locations. StockX will review them and verify them as authentic. And if they fail that test, then you as buyer don't lose any money. The sneakers are sent back to the seller, all is well. In January, they launched what they call a Vault NFT collection. And in this case, each NFT in the vault is connected to a physical item that StockX sells. So in this case, in this lawsuit, it's the Nike's Jordan 1 sneaker. So Nike sued StockX for trademark infringement, false designation of origin, unfair competition, dilution, as well as some state claims for injury to business reputation. And in the complaint, Nike alleges that StockX is basically making money off of the Nike trademark. They're capitalizing off the goodwill of the Nike brand, and they're basically misleading customers to pay heavily inflated prices for products. In this case, it's a little bit different from the Hermes case, right? So StockX is arguing that its Vault NFTs are not virtual products or digital sneakers. It's a key. It's tied to a specific real physical product that's authenticated by their service, and that it has no intrinsic value, the NFT, other than as a key to access the product. So if you own, let's say, 5, 6 pairs of sneakers, you can put them in your portfolio. You can display them. They can stay off-site until you want them. And so StockX is arguing that this is fair use. This is nothing different from using a picture or a brand on eBay or a platform, right, to sell physical products. It's the same thing. It's a fair use of the trademark, and that these are absolutely not virtual products or digital sneakers. But Nike points out, look, you guys are using this way beyond just tracking ownership of a physical product. Nike is saying that StockX's Nike brand Vault NFTs are new virtual products, that they're bundled with additional StockX services and benefits. So exclusive access to StockX releases, promotions, events. Nike also points out that even though StockX says you can redeem the NFT and take possession of the shoes for an additional charge, it also states that the redemption process is not currently available to NFT owners. It also retains the right to unilaterally redeem a Vault NFT for a so-called experiential component and take away the NFT, so you don't get the physical shoes that are supposed to be what these are for. On May 25th, Nike amended its complaint to add claims of counterfeiting and false advertising. They say they've successfully purchased 4 pairs of Nike Jordans from the Vault NFT collection that were StockX verified. They were fake. So somehow these products got through the StockX verification process, and Nike says that's counterfeiting and false advertising. So this is all happening in real time, and it's going to be really interesting to see how these cases play out. Next slide. So decentralized domain names. These are, what is a decentralized domain name? It's basically a human readable address that serves as a shortcut to your crypto wallet, right? They're legitimate, they're easy to remember, go straight into your crypto wallet. So how do you use them? Can I use it in that domain name instead of my normal domain name for my website? Not really, not yet for businesses generally. The browsers don't support blockchain's DNS unless you add a custom DNS server or resolver. And most email and other internet-based applications don't support it as well. So you need a specialized browser you have to download. in order to use them. Now, there's a few reasons why people like decentralized domain names. They're not reliant on ICANN, so if there's problems on ICANN, they're not affected. They're based on blockchain. Now, we're early in the process of these, but there's a few.
Not everybody knows what ICANN is.
My apologies. So ICANN is the it's the organization that really manages most of our typical domain names. So your .coms, your .nets, your .biz. That is the centralized mechanism to manage those. And then also, if you have a dispute, can go through an ICANN process. So because these decentralized domain names are on blockchain, they're completely separate from ICANN. ICANN has no jurisdiction. They're also anonymous. So just like a Bitcoin transaction might be anonymous, so are blockchain registered domains. Some people also like them because no one entity controls them. So censorship or otherwise, policing is difficult. So that's a challenge for brand owners. If you have a normal .com or .net, somebody's out there cyber squatting or they're using it for a site that's infringing, there are mechanisms that you can go forward and take action against them. So the Uniform Domain Name Disputes Policy Proceeding, so a UDRP, which I've handled a number of, allow you to file a complaint it's an arbitration proceeding to prove that they're using this for, they don't have any legitimate rights in the mark that's in the domain. They're using it for, an unsavory, an infringing purpose, and that it should be taken down or transferred. These decentralized domains have absolutely no centralized mechanism. So if some unauthorized third party registers a domain name in this capacity, it's not clear yet how you would enforce that.
So I have a question here. Let's say I manufacture McBurgers, and I go on Amazon one day, and without my authorization, someone's selling McBurger coupons. You buy this for $10 and you can get $100 worth of McBurgers at any of my McBurger store. What do you typically do in that case?
Sure. So most of our ordinary marketplaces and social media platforms have procedures in place for takedown. So you can notify them of an infringement, and because they don't want to be liable for contributory infringement, they get a safe harbor if they put in place these takedown provisions. So each platform has its own procedure, but typically you have a registration, you submit your registration information, and you put in a takedown notice. And so there are companies that specialize in doing that. So if you've got a whole lot of infringement, you may want to hire a third-party aggregator that does a lot of those scouring of the marketplaces or social media platforms and does takedowns. And if that's a little bit automated, and then if it needs to go up a level, your local trademark attorney can also help.
Okay, but suppose I go into a virtual mall that has like a decentralized domain. Do I still have the same procedures or rights if somebody is selling my coupons in that metaverse?
Yeah, it's not really clear. So some metaverse communities are starting to do the same, again, to try to avoid any sort of contributory infringement. Some of them are putting into some takedown procedures. And so I think my advice would be for a brand owner is, to the extent that if you're going to be in one of these virtual environments, pick one with takedown procedures. Otherwise, contact your intellectual property attorney to talk about what options might be available.
Well, if I'm McBurgers and I don't have a registered trademark because I'm young and inexperienced, am I going to have a problem with these takedown procedures and things like that?
You may. Some require a registration, so that may be your first step is getting a registration, and we will talk about that as I think in one of the next few slides.
Okay, cool.
Lauren, do you want to advance us? Thank you. So here's a great example. So some companies are already doing this, right? So McDonald's has filed a number of intent to use applications to register McDonald's, the trademark McCafe, and the Golden Arches for a variety of virtual products that are downloadable for NFTs. for providing online entertainment services, operating a virtual restaurant, and then online retail services featuring virtual goods. And other companies are doing this too. So Panera has filed for Paneraverse in similar categories. Chick-fil-A has applied for Chick-fil-A and Metaverse and Eat More Chicken, all for virtual goods and services. So we're seeing that companies are recognizing this is an area where they either need to be, or at least need to protect their trademarks in this space so that they can prevent infringement against others. Now, what's interesting here is these are intent to use applications. If you're a US applicant, you can file based on intent to use, but in order to get granted a registration, you will need to be able to prove use of your mark for the goods and services that are listed. So that's something to be thinking about with your branding and your business team, along with your IP attorney, about what should you be filing for, and then how would you make some use so you can have that registration to have that additional level of protection and enforcement capability. Next slide, please. So I'm talking to clients right now at looking about registering their trademarks for various goods and services. So all sorts of downloadable virtual goods and multimedia files, computer software, virtual reality software, particularly in entertainment and the gaming environment, software for creation, production, and modifications of digital designs and characters, avatars, digital overlays, and skins, right? These come up a lot in the gaming environment where you can create an avatar that looks like something specific, or you can buy products. So you can buy a t-shirt with a famous band name on it. There's retail store services featuring virtual goods, entertainment services, so a lot of online or virtual events, as well as providing online non-downloadable goods and services for use in these sorts of virtual environments. Next slide, please. So one way to leverage your own brand, be in the metaverse, right? So if you may want to establish your own presence in the metaverse, not only to support the trademark applications like we were just discussing, because you have to have use to get a registration, but also just to leverage it as one more way to reach your consumers and build brand awareness. It also allows you a way to monitor activity and deter infringement just by simply being in the space and having your brand front and center. So Gucci did this on Roblox. Gucci launched a Gucci Garden Experience Lands. It was a virtual space in Roblox. It was up for a couple of months, for a couple of weeks. And it was basically a multimedia experience that celebrated the brand and its vision. Balenciaga has done this on Fortnite. If you have a Fortnite character, you can buy outfits and accessories from their brands. So there's different ways you can get creative and get in the metaverse, make use of it for your own goods and services, get a registration, and then be present also to see what other people are doing. If you're on the platform, you have some visibility into what others are doing in that space. The other thing you may want to use if you're doing partnerships in the metaverse is to make sure that any agreements are appropriately documented through a license and terms of use, right? You want to put limitations on what they can do and what they can't do. You want to prevent damaging misuse of your brand. You're also going to want to have registrations and then use that registration symbol and TM designation, right? To just reinforce the idea that this is a brand you own, put people on notice of your trademark rights, and hopefully deter misuse. Can you move to the next slide, please? Thank you. So there's international considerations as well. So trademarks are geographic in nature. If you own a US registration, that protects you in the US. But let's say you have a platform that's based in Canada or Europe. The US registration may not be enough for trademark enforcement there. I had a case recently where it was a UDRP case. It was a domain name case, so not the metaverse, more typical, but more traditional. But the registrar was, the owner of the domain name was located in Pakistan, and the registrar was located in India. Now, in that case, we had an ICANN, a UDRP provision that we could go through, but fortunately, we had trademark registrations in India. So that allowed us to be able to take action. So here, you want to think about globally protecting your brands. particularly in countries where you are already active, but also where counterfeiters or known sort of platforms for these types of infringements. You can either register directly in each country, or through the EU has a centralized European Union trademark office. And then the Madrid Protocol is another option. For the Madrid Protocol, this is an international treaty that allows you to register through the World Intellectual Property Organization and designate a bunch of countries all at the same time. So there's advantages and disadvantages to each type of these proceedings, but there's a lot of options to consider. The other thing is, once you have a registration, you can register it with customs. So if you have a US registration, you can register that with customs and make information available to customs officials to catch, at least in the case of the physical product coming into the United States, where they can pick those up and detain them and bring them to your attention and possibly destroy them if they are determined to be counterfeit products. We've done this in China as well. China will allow you to register a trademark or a copyright registration with their customs organization and catch outgoing counterfeit products. So those are options. Next slide, please. I touched on this briefly a moment ago. There's different ways to monitor your brand generally, and some of this may grow and extend into the metaverse. So the typical way to monitor your brand is to subscribe to a trademark vigilance watch service. Those typically will monitor third-party trademark applications, right? We're seeing, I think Gucci and Prada are seeing people, third parties, unauthorized, filing trademark applications for their brands for use in a virtual space. And they're having to monitor those and oppose those where they occur. It also can monitor company name filings, domain names, and some common law use. What they often don't, these traditional watch services cover, are marketplaces, social media platforms, and other sort of online communities. There are several companies that offer this sort of brand monitoring service and can help to automate some of that. They'll scour it. They have different software that they can put in place to scour these platforms and try to locate counterfeit products or infringing use. As we were talking previously, if you've got a trademark registration, then you can notify them of the infringement. They don't want to be liable for contributory infringement, so they will usually remove it once they're aware of it if it meets with their procedures. Next slide.
We're going to talk about privacy issues, but let's go back one slide, if you would, because I had some questions for Lori. Now, Lori, if I own McBurgers and I don't want to be in the metaverse, but I'm afraid that everything that's in the real world is going to wind up in the metaverse, whether I like it or not, should I be concerned enough about use of the metaverse that I should have a brand monitoring service that could monitor social media platforms and the like?
Yeah, all of this is pretty new in terms of what the metaverse, some of these virtual environments are, and whether they're going to be monitored and how effectively they can be scoured. I always recommend to my brand owners, register your marks for your key goods and services in key countries where you do business. Have those registrations, maintain them, and make use so that you can enforce them. The brand monitoring services will pick up things like Amazon, eBay, Facebook, Instagram, different sort of. We see so much counterfeit products being sold through these marketplaces. So it's a business call for each company how much they want to invest in this, and I think it comes down to how much infringement are you seeing, right? There's a cost benefit to this. This is, these things are expensive. There's a cost. And if you're not finding a huge amount of infringement, maybe this isn't the moment that you need to do it, but be proactive, have the registrations in place, know about them, know where you need to go. And if you start to see some, putting some of this, nipping it in the bud early is really a valuable way to approach this. Counterfeiters are going to knock off brands. We know this. What you want to do is make it harder for them to knock off your brand, so they move on to somebody else, quite frankly. Put obstacles in their place. Make it clear that you're going to enforce it. You're going to make things hard for them. They'll move on perhaps to a different brand. So it's certainly, there's no perfect world, but you can take actions to make it hard for them to knock you off.
Sure. Now, just to put this in perspective, we're looking at the metaverse like we were looking at gaming at the inception. It's estimated by Citibank that by the year 2030, the metaverse will account for 1% of the global economy, somewhere between 8 trillion and 13 trillion by year 2030. I wasn't sure whether that trillion was the global economy or the metaverse economy, but it's 1% of some number that's pretty large. So because of this, we have the trademark and copyright issues, of course. But if we move on to the next slide, you'll see that we have a lot of privacy issues as well and cyber risk. So given all the technologies involved, the risk of being a victim of cyber attack in the metaverse is very high because of the collection of data, personal data, non-personal data, the use of blockchain and systems which are used to monitor and prevent cyber attacks are highly complex. Whatever risks we have in the real world are heightened in the metaverse. Already there are dozens of cases of counterfeit works or products in a decentralized world. And the counterfeit products remain on the blockchain for eternity, and there's no way to delete them from the blockchain because the blockchain is intended to be a ledger forever. It's also, to a certain extent, public. So through triangulation of certain factors, it is possible for evildoers out there to learn more about you personally because you're buying blockchain items or your customers are buying blockchain items and are going into certain metaverses through demographics and whatever. There's going to be a way to sort of get closer to your personal identities. And so with the phishing activities that we expect to increase because of the metaverse, one of the risks is going to be identity theft. There may be a way to steal the avatars or get into the crypto wallets. And all they have to do is get a hold of the access keys to the users of the metaverse and create havoc. But the real focus on these risks is protecting the personal data. If you're going to promote your brand, you're going to require the collection of personal data because that's how you reinforce your brand. Whoever collects the data will have privacy obligations. If you're in the metaverse and you have a site on the web in the metaverse, or if you just have a website, you need a tailored privacy disclosure in terms of use agreement. And if you're using a metaverse platform, you have to provide and align your privacy rules with platform provider disclosures. Again, there's going to be a lot of biometric data that's going to be released by users in order to take advantage of certain AR or VR devices that switch from virtual reality to augmented reality. And that biometric data that allows you to shop so easily is also going to be stored somewhere. The companies have to take precautions to make sure that these items aren't accessible. They're going to have to upgrade the security systems and make sure that they're secure and free of vulnerabilities because it's going to reflect back on the company. And then there's a question of what information should you collect, data you should collect, and how you're going to store it. If there's privacy issues that are heightened in states of the United States, such as California, Utah, Virginia, Colorado, and Connecticut. If you have international clients or users, you know that you have international privacy law obligations like the GDPR. And you're going to have to vet all these issues and do and make sure that your sites are secure and the way that you do things are the best practices, because it's inevitable that someone will try to crack what you're doing. So depending on how ambitious you are in the metaverse, you're going to need a few professionals, certainly lawyers, with certain skill sets to help hone what you're trying to do. Let's go to the next slide, please. So we'll take questions in a moment, but let's just summarize what we have here. So we have the technologies of NFTs and crypto wallets, and the metaverse are the future. Anything found in the real world is going to migrate or be taken from the real world and put into digital form in the metaverse. And once in the metaverse, it's going to be exploited in a way that may be beyond our reach, at least initially. And that's why you have to go to real world protections to start with if you want to reach into the metaverse and protect your assets, particularly IP assets in the metaverse. With the technology complexity in the metaverse, in order to make it work well, it's going to increase cyber risks and privacy issues, as if they weren't bad enough. So as Lori told us, got to keep those trademarks and copyrights really strong, and you got to monitor. You just can't allow them to sit, be legally strong without making sure that nobody's stealing them from you day to day. It's really important for you to avoid exposure, and also to help your constituencies, your customers, and others to consult with privacy law experts to avoid the issues. Yes, we're trying to scare you a little in addressing these issues, but also we're trying to alert you a little that these are real issues, so you can get in trouble here. So once you talk with your experts, you can go into the metaverse where no one has ever gone before. So let's go to the next slide. We can take questions. Let's see if there are any.
Not any current questions. If anyone has any, please feel free to put them in the tab, in the questions tab.
One of the questions is, are there any particular products or services that do better than others at this point in time in the metaverse? What's the what's the chain of commerce we see most often in the metaverse, especially in the franchise companies? I see there's two things. One thing is art or pop art, like the Meta Birkins and Rockstar paraphernalia. Another thing I see is the fast food giants wanting to protect and stake out the ability to make a metaverse order and have it delivered or fulfilled using autonomous vehicles or hovercraft or whatever. Lori, do you have anything to add to those observations?
Yeah, I mostly see it in the video game space. So that's a really active area where if you're on Roblox or Fortnite or some of these other spaces, that the avatars can, wear different things, do different dances, do many things that we can do in the real world. And I read somewhere a statistic that the revenues from video games now is either the same or more as film, television, and music put together. That gives you some sense of just how active it is.
As well. It has been more than the Hollywood studios for a long time.
Sure. And so, that's something where I see it active. And I think, like you say, I have a number of entertainment clients that are primarily in the music business, but they're also artists on the side. And so selling some of their artwork can garner a huge amount of money in NFT form. So we see that as well. I had a question for you in terms of, do you have franchise companies that come to you about the metaverse? What are their biggest concerns that your clients are bringing to you?
I think that their concerns are, I think most of the concerns are dealt with in-house. They're afraid to talk about them in some ways. So I haven't been privy to those conversations yet.
Fair enough.
Other than the conversations of are my trademarks secure? Yeah. And it sort of hints that they're going in the metaverse, but they haven't talked to me about once we're in the metaverse. But there's a question here that really goes to your question of me, Lori. Someone asks, I'd like to clarify, are you suggesting that there's another form of trademark for the metaverse, or would an existing trademark suffice to protect one's assets in the metaverse?
Yeah, that's a good question, because let's say you are a sandwich company and you have a trademark registered for sandwiches and restaurant services, but somebody is, using your trademarks for something slightly different in the virtual environment. There's a likelihood of confusion analysis that most courts consider, right? How similar are the marks and how related are the goods and services? So if there's sort of a consideration now of, is a sandwich considered confusing? Is it related enough to a t-shirt with that brand, a virtual t-shirt worn on an avatar in a virtual environment? Is that a confusingly similar, is that a related good or service? And so the way you enhance your scope of rights is by having registrations in that space, because then if you're comparing a sandwich with software, in a virtual space, right, on its face, those seem quite different and unrelated. But if you also have a registration for virtual products yourself, for software, for downloadable or virtual goods, it's a closer analysis. So I think that's the reason for maybe registering in these different categories.
Now, trademarks have a geographic protection once they're registered, but in the metaverse, we're not sure where that geographic protection starts and ends, do we?
Not yet. These are the things we're starting to figure out. I see there's additional questions. I can't seem to maximize my screen enough to read them all. I'm not sure if you can, Greg.
Yeah, I'll read the next question. There's a number of different places that are defined as the metaverse, but if you could name the top places, is it Sandbox, Roblox, is it Fortnite? Where can the metaverse be found?
It's all of that, right? I mean, it's any sort of virtual environment, augmented reality environment, so Decentraland, Roblox, Sandbox, Fortnite. It's all of those and more. Craig, do you have anything to add to that?
No, I would for those want to dip their toe in the water, try wendyverse.com. It'll give you a sampling even without virtual reality specs. Next question is, with so many decentralized worlds, how do you prioritize where to start? How do you protect yourself in so many different worlds? In your experience, are brands paying attention to things like Bored and Hungry Ape, NFTs, or other concepts like Mr. Beast Burger, which were often overlaid on top of existing restaurant offerings and the competition that this brings? The answer is yes, without question, that people are paying attention to Board Angry Apes NFTs, Mr. Beast Burgers, the restaurant, all the restaurant trade magazines are talking about these things all the time. And you have to pay attention because this is the future, and there's a lot of creative stuff going on. So that's why every one of the big burger places are running Chick-fil-A as well. They're chicken, but they're like big beef. They're all running to protect their rights in the metaverse, even if they don't intend to open up a metaverse offering right away.
I would add that this is, like any branding strategy, this is specific to the company and your branding goals, right? So there's protection. Once you register your mark and you protect it for virtual goods and services, that's the starting point, right? That you can then take to whatever platform and whatever procedures are available there. And the next question is, where do you yourself show up? And I think that's really an individualized approach. Who are your customers? Who are your target audience? And how do they best engage with you? Is it through coupons? Is it through virtual experiences? Is it through customized products that their avatar can wear in a video game? Is it, what are the partnerships and collaborations that makes sense for your business and your target customers? And I think there's some thought to really be put into that. And then also looking at the platforms that you're considering, what are their procedures for enforcement against infringement and counterfeiting, right? Are you on a platform that is a good trademark partner? Are they going to stand with you for someone who's using your brand in an unauthorized way? There's a lot of considerations that can go into this, both from where do you show up in virtual spaces, how do you engage in the virtual environment, and then how you can protect your marks once you're there.
And also the brand plan in the metaverse. I mean, we have brand plans for how we're going to bring out new initiatives in the real world. And just imagine the metaverse, how are we going to coordinate couponing in the metaverse to bring people into the real stores, and in the real stores, bring people into the metaverse stores, and what the proper mix should be. Also, there's geographic considerations. The metaverse, even though I have a choice of going to the mall or my McBurgers, within a 10-minute drive, but the metaverse can reach people who are outside of my regional development. And how brands expand is typically not one in New York City and the next one in Singapore. But in the metaverse, it could be that way. The reason one does not go from New York City to Singapore next is because it's hard to support it. But in the metaverse, you could do that. So people will have to think about brand extension and expansion without respect or with different respect to geography. So all these things have to be considered. And that fulfillment piece, how you're going to get the product that you buy, is also a consideration. Well, we're just about out of time. Here's a question. Which worlds are the best at supporting trademarks? I don't know the answer to that question. Maybe you do, Lori.
I have no comment on that. To be determined.
Determined. The ones with the best experience in takedown responsibility are the ones that best support the trademarks, as far as I'm concerned.
The ones that are at least starting to step up with their own procedures, I think, are at least ahead of the pack, right? So, but we'll see. Again, we're sort of on the cusp of a lot of these things, and I think we're going to see as the courts are grappling with this, how this plays out, who is found to be held liable for infringement, I think then is going to determine behavior. So, you know, we'll keep you posted.
That's good observation. Well, thank you all for joining us. It's been really great. Can't wait to do this again when we have even more experience and knowledge about the subject. Thank you, Lori, and thank you everyone for tuning in.
Awesome.
Thanks,
Thank you
everybody.
so much. This was excellent content and excellent feedback from all of you. We really do appreciate it. Again, this webinar was recorded, and along with the presentation deck will appear on our website early this evening. You'll be able to find that at community.franchise.org. Thank you very much again to Craig, Lori, and the Fox Rothschild team, and thank you to everyone for tuning in. Have a great rest of your day and stay safe and healthy. Bye.